In this module, I'll be discussing the domestic surveillance legislation that currently exists in Australia, the UK and US. Understanding the nature of domestic legal frameworks will give a better appreciation of the values at play in this field of law and create a basis for investigating the international cyber law standards that we will discuss later in this course. In respect of Australia, the Federal Privacy Act was, among other reasons, implemented to reflect Australia's privacy responsibilities in accordance with the United Nations International Covenant on Civil and Political Rights and other international standards, such as the OECD Guidelines on the Protection of Privacy and Transport of Flows of Personal Data. These privacy obligations regulate the management of personal information by a number of Australian government departments. Australian intelligence and defence intelligence agencies are explicitly exempt from the direct provisions of the Privacy Act. These exemptions are accepted by bodies such as the Australian Law Reform Commission to be consistent with international standards, but come with a number of corresponding safeguards within legislation, accountability processes, and oversight mechanisms that apply to intelligence and defence intelligence agencies. Metadata is often collected by Australian intelligence agencies in accordance with the Telecommunications Interception and Access Act. While metadata is not explicitly defined in Australian law, Section 172 of the Federal Telecommunications Interception and Access Act 1979 negatively defines metadata as a supply of telecommunications data that does not disclose the contents or substance of a communication or document. Metadata is therefore the information about a communication that remains after its contents are omitted. Requests by intelligence organisations to access existing metadata can be made by the Director General of Security, the Deputy Director General of Security, or an employee of the Australian Security and Intelligence Office, ASIO, or ASIO affiliate. The Telecommunications Interception and Access Act specifies that the information may be released if the request is aligned with the purpose of the relevant organisation and its activities. While warrants are not required to obtain metadata, the information available from this data is limited in order to protect the privacy interests of Australians. For example, telecommunication providers have traditionally only been required to provide records of calls that were traditionally maintained for billing purposes. Due to the development of online communication, internet service providers have similarly been obliged to provide IP addresses, sender, recipient, and time and date information for email communications. Again, it is important to note that for both traditional telephonic methods of communication and for online communication records, no content must be recorded or provided to law enforcement unless subject to a warrant. In Australia, there is a general prohibition against the interception of telecommunications, and this is enshrined within Section 7.1 of the Telecommunications Interception and Access Act 1979. This means that it is an offence to access stored content or intercept communications through a telecommunications system without the knowledge of the sender or recipient. There are, however, exceptions to this provision, including exceptions for intelligence gathering purposes. There are two warrant-based processes that allow for the interception of the content of communications under the Act. Firstly, there is the ability for the Australian Government and state agencies to apply for a warrant from a judge or Administrative Appeals Tribunal member. Additionally, in order for a security organisation to obtain a warrant for surveillance, a request may be made by the Director General of Security to the Attorney General in accordance with Section 9 of the Telecommunications Interception and Access Act. Section 9 requires that the Attorney-General must be satisfied when granting the warrant that the proposed interception of communications will, or is likely to, assist the organisation in obtaining intelligence relating to security. Warrants must be similarly obtained to access stored content communications. In 2014, a Bill of Amendment was proposed to alter the Telecommunications Interception and Access Act. These amendments propose that all service providers in Australia must keep standard records of telecommunications data for 2 years in order to support the investigation of crimes and threats to national security. Service providers will not be required to retain the content or substance of communications, including posts on social media or email subject fields. The retention of web browsing history is expressly excluded, and there is no requirement to keep detailed location records, avoiding captured data being utilised as a location surveillance device. Turning now to the United Kingdom, two of the most important pieces of legislation pertaining to surveillance in the UK are the Data Retention and Investigatory Powers Act 2014 and the Regulation of Investigatory Powers Act 2000. Under Section 1.1 of the Data Retention and Investigatory Powers Act 2014, the United Kingdom Secretary of State may require a public telecommunications operator to retain relevant communications data if the UK Secretary of State considers that the requirement is necessary and proportionate for a purpose that falls within Section 22.2 of the Regulation of Investigatory Powers Act 2000. In particular, Section 22.2 of the Regulation of Investigatory Powers Act 2000 states that obtaining communications data may be deemed necessary in the interests of national security, for the purpose of preventing or detecting crime or of preventing disorder, in the interest of public safety, or for any purpose not specifically mentioned in Section 22, which is specified for the purposes of subsection 22 by an order made by the Secretary of State. Communications data is defined in the Regulation of Investigatory Powers Act 2000 as any information which includes none of the contents of a communication and is about the use made by any person of any postal service or telecommunications service. A retention notice issued by the Secretary of State may require the retention of all data or any description of data. This notice will specify the period or periods for which data is to be retained. In the United Kingdom, 12 months is currently the maximum period for which data is to be retained under a retention notice. Turning now to legislation in the United States. It is important to acknowledge that there is a significant political debate regarding the classification of metadata collection in the United States. This comes partly through the US constitutional guarantees regarding search and seizure provisions and whether these provisions, which traditionally related to physically breaking into citizens' homes, can apply in a digital world and to the collection of metadata. Congress established the Foreign Intelligence Surveillance Court in 1978 in accordance with the Foreign Intelligence Surveillance Act of 1978. The court's function is to assess applications made by the US government for electronic surveillance, physical search, and investigative actions for foreign intelligence purposes. In recent times, metadata has been collected in the US in accordance with, inter alia, Section 215 of the US Patriot Act, which amended the Foreign Intelligence Surveillance Act. The Patriot Act has been interpreted by the US government to authorise, on warrant from the FISA court, the storage of bulk telephony metadata within the US. Section 215 of the Patriot Act requires there be reasonable grounds to believe that the metadata accessed under the provision is relevant to an authorised national security investigation. The metadata collected includes the numbers of both recipient and outbound caller, the time of calls, and the date of calls. Orders for the collection of metadata are generally authorised ex parte to ensure the success of operations. Mass data collection by the United States government allows security organisations to find patterns and connections, aiming to detect threats and helping the government to rapidly identify terrorist operatives and networks. We heard in an earlier module Mr. Ren Gady of the US National Counter-Terrorist Centre speak to the usefulness of this data in the NCTC's mission. A general prohibition against government access to the content of communications exists in the United States. However, similar to the other domestic regimes I have discussed in this module, this prohibition is subject to a number of exceptions. The first exception exists when a warrant is issued by a federal judge on finding of probable cause that an individual has committed, will commit, or is committing a crime, and that communications intercepted will relate to the crime. The second exception exists when a warrant is issued from a judge of the FISA court. The purpose of surveilling an agent of a foreign power who is inside the United States, including individuals engaged in international terrorism, for the purpose of obtaining foreign intelligence information. Executive Order 12333 specifies the missions and authorities of each element of the intelligence community and sets out principles that aim to strike the appropriate balance between personal privacy and the collection of information for intelligence purposes. To briefly summarise this module, It is clear that the collection of metadata is lawful under Australian, UK and US domestic legislative regimes. If a government or intelligence agency wishes to access the content of communications rather than just the metadata, a further set of requirements need to be met, usually in the form of obtaining a warrant. While the specifics of these warrant applications differ from state to state, it is evident that all three states share the notion that both metadata and the content of communications should be accessible to intelligence agencies in the interest of national security, but only if it is deemed reasonable and necessary that they are allowed access to that information. Clearly, there is a constant drive for balance between the privacy of citizens and the protection of national security within the domestic legislation that I have discussed.